If you've been watching my videos for any length of time, you know that I am a big proponent of domestic asset protection trust, despite the fact that it has what's called inherent limitations within it. Simple reason is because usually the asset or the laws that are governed are within the US forum, and so those are the parameters in which you can play around. Well, not to worry. In this video, I am going to give you 3 pointers in how to strengthen the language within a domestic asset protection trust. Greetings, my name is Patrick Fenkau with the Asset Protection Center. I am an estate planning attorney focused in the field of asset protection and elder law out in the state of California and Florida. So there you have it. You've taken the first step in wanting to protect your assets, and you want to do it within a domestic asset protection trust. So how can you strengthen the language? Well, first and foremost, let me take a step back and let me encourage you to steer away from the pure concept of self-settled trust. Again, I am the grantor, I am also the beneficiary. It's one and the same. Even if you do it in the states that recognize such as Nevada, Wyoming, Alaska, I would encourage you to steer away from that type of pure concept, because depending on the state in which you reside, that may not be recognized. So let me give you 3 pointers in order to help you create a strengthened version of the same instrument. So first and foremost, as I've reiterated, let the grantor not be the beneficiary. You want to create it for a third party, your children, your grandchildren, your spouse. There is a litmus of options available to you in order not to create that direct relationship between yourself as a grantor and you as the beneficiary. Now, another concept is that you do not want the beneficiaries to retain what is called a special power of appointment, which is a testamentary concept. I won't go into too much details over it in this video, but suffice it to say, special power of appointment is not a control you want the beneficiaries to retain. And another idea, finally, is the clause or the language that is known as discretionary distribution with some type of ascertainable standards. So what do I mean? Discretionary distribution, the trustee, that the individual that you appoint to make distributions will have the ability to decide whether he or she wants to make those distributions. But you want what's called ascertainable standards in order to have some type of directions, instructions, so that the person is not completely left up to their own device as to what to do with the assets. Ascertainable standards fall under health, education, maintenance, support. So that way it will help the individual at least have some type of guidance. Well, the beneficiary wants to buy a Corvette. No, that usually doesn't fall under those standards. The beneficiary wants to get an education. That falls under that. A college would be something that would be encouraged through the trust, and that can be used, the assets can be used to distribute and pay for those, for that education. So there you go. Those 3 ideas will help you create a strengthened version of a domestic asset protection trust. Again, try to steer away from the pure concept of self-settled trust. If you want to find out more, go ahead and visit us at assetprotectioncenter.com or call me at 714-966-2646 and we'll talk about your situation. Thank you for watching, and I'll see you next time.